In this session, we're going to conclude our examination of employment discrimination related statutes. So the last one we're going to talk about is the Family Medical Leave Act, known as the FMLA. You'll note that all the other things that we've talked about so far, the ADA, the ADEA, Title VII, all those acts are subject to the EEOC investigation process. As you'll recall from our first discussion on this chapter, the EEOC is a prerequisite to getting a lawsuit filed in court. You've got to go through filing a charge with the EEOC, allowing them to investigate it and issue the right to sue letter. At that point, you then have 90 days to file your lawsuit in court. The FMLA, you don't have to do that. If you have an FMLA claim, you can go directly to the courts and file your lawsuit. You don't have to go to the EEOC first. So under the FMLA, employees are entitled to 12 weeks of leave for qualifying conditions. So the FMLA applies to employers who have 50 or more employees within a 75-mile radius for at least 20 work weeks in the current or prior calendar year. If you have that number of employees within a 75-mile radius, then you're going to be subject to the FMLA and must provide eligible employees 12 weeks of leave when they qualify for it. So an employee is eligible for FMLA leave if the employee has worked for at least 12 months and they have 1,250 hours worked during that time. So if you're a covered employer and it's an eligible employee, then the employee will be entitled to leave under specific conditions. And we'll look at that on the next slide. But before that, FMLA leave is unpaid. So the federal law does not require you to provide paid leave to the employee. Tennessee has a comparable law, and it also is an unpaid leave. It does not require you to provide paid leave. That does not mean that the employee can't decide to provide paid leave if the employer wants to. Employers are certainly allowed to, but they're not required to by federal law. It's possible and it's recommended that an employer require that any FMLA leave be taken concurrent with paid leave. So if you've got vacation time, require the employee to take FMLA leave concurrent with their vacation time. So if they're using their vacation time in addition to their FMLA leave, then the employee would not be able to have more than 12 weeks of leave. If you didn't require that they run concurrent, then the employee could be out for 12 weeks of leave, and if they have 4 weeks of vacation time or paid leave, they could then take another 4 weeks. So they could be off a total of 16 weeks under that scenario. So the qualifying conditions. This is when an employee would be entitled to FMLA leave. So birth or adoption of a child. If a child is born or if you adopt a child, you would be able to qualify and have up to 12 weeks of leave in a 1-year period. And now we've said 12 weeks of leave, and that resets every year. And so it may be based on a calendar year, it may be based on the year since you last took it, or since you first took FMLA leave. There are different ways that you can calculate that, but it resets every year. And so another qualifying condition is care for an employee's spouse, child, or parent who has a serious health condition. And we'll define serious health condition on the next slide. Another qualifying condition is when the employee has their own serious health condition. Another one is where there's a qualifying emergency that arises out of the fact that a spouse, a child, or a parent is on active military duty. And the last qualifying condition is to care for a service member's serious injury or illness. If you're taking leave for a service member's serious injury or illness, the leave time increases from 12 weeks to 26 weeks. So 26 weeks would be, you could be off half a year to care for service members' serious injury or illness. Serious health condition exists if you have an absence from work of more than 3 days, and that absence requires outpatient treatment of 2 times or more within 30 days, or one visit followed by prescription medication or ongoing treatment. So it may be a serious health condition if you are off work for 5 days and you've seen a physician and giving prescription medication to take for 10 days. That would be enough to establish a serious health condition. Now, the employee is required to give notice. They're required to provide notice so that the employer will know when the employee is trying to use their FMLA leave. Now, when we say the employee has to give notice, that's a real loose requirement. Some employees may come up and say, I need to take leave under the Family Medical Leave Act. But a lot of times the employee just tells you, I've got to be off work for several weeks due to having a surgery, or I'm sick and my doctor says I've got to be off for a week. In those instances, the employee is probably telling the employer enough information to where the employer then has the burden to recognize that this may be FMLA qualifying leave, and then the employer should seek more information to determine if the leave qualifies for FMLA. So the employee initially has the burden to tip the employer off that he may or she may need FMLA qualifying leave. The burden then goes to the employer to recognize that and to classify it as FMLA or seek additional information if it's needed. So to be able to get that additional information that's needed to determine if it is FMLA qualifying leave, the employer may require a medical certification. So this would be a form that the Department of Labor has that you would provide to the employee and have the employee's doctor complete it and return it to the employer. And it should hopefully give information about the illness or injury that the employee has that may be keeping him, or it may be for a spouse or a family member, or like a son, daughter, or a parent. And you would get enough information about the serious health condition to know whether FMLA leave is appropriate or not. So once you do decide that it's FMLA leave, then the employer must provide a notice within 5 business days of making that determination. And you've got to give that notice to the employee so the employee can know that, hey, I'm off work, but it's counting against my FMLA time. If you send the medical certification, it's supposed to be returned in 15 days. It may not be a surprise to people, but doctors' offices are often slow, and something like this that they're not getting paid for does not rise to the top of their list. So it's not uncommon for employees to have trouble getting these returned to you within 15 days. If the employee is untimely, your best recourse is to just tell the employee that and encourage them to try to get the doctor to return it, because a lot of times the fault lies in the doctor, not the employee. Now, by the same token, you may consider calling the doctor's office and telling them that you need it and why you need it, and it may help encourage the doctor to complete your certification. So if the certification is either incomplete or insufficient, then you got to inform the employee of the incompleteness or the insufficiency of it and indicate specifically what information you still need, and then you give them another 7 days to try to cure either the incomplete or insufficient certification. So when we say incomplete, that's exactly what it means, in that the doctor didn't complete part of the certification. They may have missed a question, they may have not written in, they may have not checked the box. It's where they missed filling out part of the certification. An insufficient certification, by contrast, is where they filled something out, but it's not clear what they meant. They may have wrote a term out, but it's vague or it's ambiguous and doesn't give the employer the information it needs to know whether this is leave that would qualify for the FMLA or not. That's when you would inform the employee of what you need and give them another 7 days to cure. If the employee fails to obtain a complete certification, then the employer may be able to deny FMLA leave. Denial of FMLA leave is a high-risk decision. The employee may sue you for a violation of interfering with their FMLA rights. So on these certifications, once you get it certified, it's not always necessarily, it's not an indefinite certification. At a minimum, employers can seek a recertification every 6 months. You can also seek a recertification if conditions have changed such that the need for leave is in doubt. So it's usually when you have suspicious circumstances. So if Anthony has gone out on leave because he injured his back and he needs to be off work, but you learn that Anthony is well enough to play in his church league basketball team, then you may wonder, playing basketball but he can't work at your office, that it makes you question whether his back is really still hurting such that he can't perform his job. So in those circumstances, you would have a good basis to doubt that his leave is still needed. And in that scenario, you could seek a recertification to confirm that Anthony's back is still in such shape that he must be off work. For the last topic, let's talk about some of the damages that could be awarded to an employee for violating some of the statutes we've talked about. So for a Title VII claim, an ADEA, an ADA, if the employer is found to discriminate or retaliate against the employee, what would their damages be? Well, we're going to look at these briefly. The first type of damage that the employee may be able to recover is called back pay. The intent of back pay is to compensate the employee for what they lost because of the discrimination or retaliation. So your intent or the purpose is to restore the employee to the status quo that he or she would have enjoyed if they had not been terminated or demoted, whatever the discriminatory action is. By discriminatory action, I mean the adverse employment action. So if the employee, let's take the example, if they've been terminated, then you restore them or compensate them for the damages that they lost, the opportunity they lost because of the termination. So it's kind of the idea of you make them whole, you put them back in the position that they would have been in had the discrimination not occurred. So an award of back pay is going to include compensation for things such as their wages or their salary, which could include overtime if you get overtime, sick leave, vacation pay. You also get compensation for your benefits, the value of your 401k contributions, the value of your health insurance premiums. All of that is going to be included in your back pay. So the time period that the back pay is going to cover, it's going to extend from the date of the adverse employment action. So in termination, the day you're terminated, until the jury reaches its verdict in the case. And so that's going to cover the period that you were more or less deprived of your employment benefits, your salary, wages, overtime, 401k contributions. You're going to get reimbursed basically for what you did not get because of the discriminatory action of the employer. So with back pay, we talked about the doctrine of mitigation of damages when we talked about contracts. And if you recall, in contracts, the non-breaching party is required to undertake efforts to limit the losses that he or she incurs. Well, the same intent applies here. The employee can't sit at home, take no effort to find a job, and then seek and expect to recover everything. The employee has a duty to try to mitigate his or her damages. And the way that they mitigate that is they go and they seek alternate employment. So you have a lot of these cases where they come up and the employee claims that they've looked high and low, they've applied at all these places, but they failed to find employment. And that becomes an issue for the jury to decide. So you may have an employment discrimination case where you're calling an expert to establish that the job market is strong for this individual, that he or she should have been able to have found a job. That should be taken into account and may serve as a basis to limit the amount of back pay damages. So if they did in fact find alternate employment, then the back pay award would be offset. So let's use easy numbers. If the person's value was $100,000 per year, and it was 2 years from the date of termination to the award at trial, then they would be entitled to $200,000. But you look at it and say, what did the employee earn during this time? If the employee was actually working and earned $75,000, then the amount of back pay damages would be $125,000. So it's funny on back pay. I have a case recently that's it involves a CRNA, a nurse anesthetist, and she was terminated, and she found employment within about a month. And we just mediated the case recently in an effort to settle it. It did not settle because of unrealistic expectations, but this CRNA was terminated. She claims it was discriminatory. Um, our client says that it was not discriminatory, something to fight over. But the interesting part is that she got a job within a month making $20,000 more per year than what she was making at the employer that terminated her. So they terminated her. She was off work for a month, and then she's now got another job making more money. So our argument at mediation is she has virtually no damages. She's back working. She only had a month gap where she didn't have any job, and so her damages were about $12,000 for that month, and then she's back working, making more money. And so our point is that when you offset that, she's actually made more in the time period. Once we get to trial, she will have made more than she would have lost, and so she doesn't have any back pay damages. And so the interesting part to it is that arguably this lady was terminated, but she's better off, so she really has suffered no damages as a result of any discriminatory conduct. So if she does prove discrimination, her damages will be quite low. Front pay, this is another award that's given. It's an equitable remedy, and it's one that is awarded at the judge's discretion. So this is not a mandatory award. On back pay, it's going to be mandatory that you're going to get the value of what you lost from the date of the adverse employment action until the jury renders its verdict, subject to the offset based on mitigation efforts and what was earned. But the front pay is something that there's no requirement on. A judge may look at the case and the factors it has. There's a set of factors that a judge will apply, and they may look at it and say, we don't think this is an appropriate case to award front pay. Front pay, back pay compensates you for the time that you've missed. Front pay is a forward-looking remedy. It's meant to award money damages for lost compensation into the future. So if it is a hard economic time, it's more likely that a judge will award front pay because they'll look at it and say the employee lost his job because of discriminatory conduct. He has not been able to find a job yet, and they'll estimate that it may take another 1 year or 2 years before that employee could find suitable work. And so they award additional compensation to help cover the future period that the employee will have to be searching for a new job. There's, again, no set formula to this. It's just at the judge's discretion. So it could be 6 months, it could be 3 years. Typically, judges don't award more than between 1 to 2 years. It's always possibility within their discretion, but usually it's not. And in the strong economy that we have had over the last few years, the likelihood of having front pay awarded has decreased. And if you are employed then it's highly unlikely that the judge is going to award front pay because you don't need any additional compensation for the future. You already have a job, you're already making money. Now it's possible that you may have a job in which you make less money than you were making initially. And in that scenario, the judge may award you some amount of front pay to help compensate, to fill the gap between your pay levels. So if you were earning $50,000 at the job you were terminated from, and then in your new job you're earning $40,000 a year, the judge may award $10,000 per year for 2 years, and that would be meant to help compensate you for your loss in income because of the discriminatory conduct. Front pay would also be subject to the same mitigation arguments that we discussed a few moments ago, meaning that a judge could take into account the lack of your efforts to find employment. And if you have not been diligent in finding employment, the judge may either lessen the award of future damages, or he may not award future damages altogether. Another component here is compensatory damages. Compensatory damages, unlike the damages of front pay and back pay, where you're awarding something based on somewhat of a formula, some set of numbers. You're taking into account what the person has earned, less what they're earning now, things like that. But here, compensatory damages, there's no formula. It's really left to the discretion of the jury. And so compensatory damages is designed to compensate the employee for humiliation he or she may have suffered, embarrassment that they may have suffered because of the discriminatory action. A lot of times the employee is going to claim some sort of mental anguish or mental harm. It would cover that in this type of award. You would also cover out-of-pocket expenses for things like medical treatment associated with like the mental anguish if they saw a counselor, something like that. So here it's kind of at the jury's discretion. They may put a number on the alleged humiliation and mental anguish at $20,000, or they may base it on $100,000. But as you see down here at the bottom, there are some limits to the amount of compensatory damages that may be awarded, and it's based on the size of the employer. If you have 15 to 100 employees, and the cap is $50,000. Between 101 and 200 employees, it's 100,000. Between 201 and 500 employees, it's 200,000. Any employer that has 500 or and one employees or more, the cap is $300,000. Now, I'll also say that depending on the circumstances and who the employer is, the plaintiff may be entitled to some sort of punitive damages. Some refer to them as liquidated damages, some refer to them as punitive damages. It just depends on the statute that you're trying to recover under. I will say that punitive damages via Supreme Court opinions cannot be imposed against public employers, meaning that a city, a county, a state government, they would not be subject to punitive or liquidated damages under these clauses, under these statutes. So this is kind of the same idea. It's reserved for intentional conduct. So if you can establish that the discrimination was intentional, then you may be able to recover these higher damages, which are meant to have a punitive deterrent type effect. It's just the same purpose that we've talked about when we've discussed punitive damages in previous videos. So with it though, you're also subject to these caps with a lot of the punitive damages. So again, compensatory and punitive damages can't exceed either the $50,000, $100,000, $200,000, or $300,000, depending on the size of the employer. So the last component to damages in these cases is attorney's fees. If the employee prevails on any claim, even if the employee alleges 10 claims but they only recover on one, because they recovered on that one, then the employee is entitled to some measure of attorney's fees. Now, how much attorney's fees they're entitled to and the hourly rate upon at which they will be reimbursed is all subject to argument between the parties, and ultimately will be decided by the judge. So, in a case that you have, like I said, you may allege 10 claims, but you only prevail on one, the judge may not award as many hours for an attorney's fee award as is if you had prevailed on 8 or the 10 claims. But it's still possible that the judge may award you your full amount of attorney's fees. So in these cases, attorney's fees can range from, especially in a case that was taken to trial, they will more often than not exceed $100,000, and they could even reach up to $500,000 depending on how many attorneys are involved with representing the employee and how many claims there were, and especially in these cases where you may have more than one plaintiff, you may have 2 or 3 employees that are suing the employer. In that scenario, you could have 3 different lead attorneys, or maybe some attorneys helping those 3 attorneys, and it could just get very expensive. So I say it could be up to 500,000, and I put the limit on 500,000 because that's the largest I think I've ever seen requested. But certainly, in some of these class action lawsuits and things, attorney's fees requests can get into the millions of dollars. But I think the ability to get attorney's fees is one of the primary reasons that you're seeing an increase in employment law cases. It's a lucrative area for the attorneys that represent these employees because if they win, they're going to get reimbursed for all their time, just about all their time, at a good hourly rate. And usually the employer is one that has the financial ability to pay the judgment, so they're likely to actually receive their attorney's fees that they're awarded. So I think that the attorney's fees, the ability to recover attorney's fees, is at least one contributing reason or factor as to why over the last 10 years you've started to see more employment law claims be made.